It's after 3, so I'm going to start. Okay. Good afternoon and welcome to the October meeting and program of the San Fernando Valley unit of the League of Women Voters of Greater Los Angeles. I'm Joyce Batten, acting today as chair of our unit. We're very happy that so many of you could join us today. I'm guessing that some of you may be new to the League, so I'm going to tell you a little bit about us. We are a nonpartisan political organization dating back over 100 years when the 19th Amendment to the Constitution was ratified and women won the right to vote. We encourage informed and active participation in government. We work to increase understanding of major public policy issues. And we try to influence public policy through education and advocacy. So that's who we are. Yes.
I think we have to unmute our speaker.
Oh, okay.
Yeah, he's put in the chat, Joyce, that he's not hearing.
Oh,
What you're saying.
Okay. How do we do that, Paula?
That would be on his side of if he's not hearing the audio. Can everyone else in the chat write if you are able to hear Joyce, please?
I can hear her.
I can hear.
Yeah.
I can hear.
And
Yes.
evidently,
On my desktop computer, I can't hear anything.
Oh, we can hear you now.
but he still can't hear us.
I don't know what you mean by
I
That
can
would be-
tell from his expressions that he can't hear us.
I'll go ahead and private message him, but that would be an issue, unfortunately, on his end. I don't have any control over that.
Okay.
We don't have a brilliant guy that knows everything that can tell him what to do.
Oh, in this group, Jean, come on.
Oh, sure, we got good. We have lots of good people that know everything.
You need a 15-year-old.
Is he
Hello?
running?
1, 2, 3. Suggestion,
You know,
Professor Chermerinsky,
If you can
If
hear
you-
me, as the last message said, I will just go ahead and talk. I am connected through Wi-Fi on my desktop in my office.
perhaps if you go
I
to,
did check the sound bar at the top of the computer and it's all the way to the right.
okay, he can't hear it. Okay, I'm sorry, he can't
How
hear.
about this? If you can hear me, just wave at me. Okay, I'm going to just go ahead and talk,
Yes.
even though I can't hear you. Put questions in the Q&A or the chat when it's time
Yeah.
for questions. Well, I got a message. Should I log in and log out again? I can try that. But if you can hear me, why not just go ahead and do this?
Okay.
Okay.
I'm going to go ahead and do this. Is that okay? Give me a
Yes.
thumbs up. Is it okay just to go ahead and talk? Okay. Good afternoon. It's wonderful to have the chance to speak with you. It is a momentous time in the United States Supreme Court. The decisions from the end of June of 2022 dramatically affect all of our lives, often the most important and intimate aspects of them. I can think of very few years in all of American history that were as dramatic and momentous as October term 2021. What I want to talk about is what happened last term, focusing on some of the major cases, and then talk about what's on the docket for this term, and then be glad to take your questions. 2 years ago, when Justice Ruth Bader Ginsburg died and Justice Amy Coney Barrett was confirmed, I made 2 predictions. One is we would see many more 6-3 decisions. Simple arithmetic explains why. There are now 6 conservative justices, all appointed by Republican presidents, and 3 liberal justices appointed by Democratic presidents. Last year, those were Justices Breyer, Senator, and Kagan. Now it's Justices Sotomayor, Kagan, and Jackson. This is unique in American history. Until very recently, We had liberal justices appointed by Republican presidents. Think of John Paul Stevens or David Souter. We've had conservative justices appointed by Democratic presidents. Think here, for example, of Byron White, or before that, of Felix Frankfurter. My other prediction is we'd see many fewer 5-4 decisions with the liberal justice in the majority. Again, simple arithmetic explains why. When Justice Ginsburg was on the court, she, Breyer, Sonoy, and Kagan only needed to attract 1 vote in order to create a majority. Now they need to get 2 from a court with staunch conservatives. Last term, it's officially known as October term 2021, bore out these predictions. The Supreme Court decided just 58 cases with signed opinions after briefing and oral argument. It's a bit more than the 54 from the year before, or 53 from the year before, which was the fewest number decided by the court in a year since the Civil War. And of those 58 cases, 19, or more than a third, were 6-3 decisions. Another 9 were 5-4 decisions. But that doesn't really tell the story of how conservative last term was. It wasn't the court moving the law incrementally to the right, but the court moving the law dramatically to the right. You might have seen an article in the New York Times after the term ended, describing it as the most conservative term by its statistical analysis since 1931. Let me focus on a few of the areas to show you what the court did and why it matters so much. The first area, not just alphabetically, but in terms of the significance of the term, was with regard to abortion rights. And the case was Dobbs versus Jackson Women's Health, and it was decided on Friday, June 24th. As you know, the Supreme Court expressly overruled Roe versus Wade. In 1973, in Roe versus Wade, the Supreme Court held that states cannot prohibit abortions prior to viability. In 1992, in Planned Parenthood versus Casey, the Supreme Court reaffirmed that states cannot prohibit abortions prior to viability. Viability is said by science and medicine to be about the 23rd or 24th week of pregnancy. The issue in Dobbs was a Mississippi law that prohibits abortions after the 15th week of pregnancy. It's worth noting that both Roe and Casey were bipartisan decisions. Roe was a 7-2 decision. The majority opinion was written by Justice Harry Blackmun, who had appointed to the Supreme Court by Republican President Richard Nixon. The majority also included Chief Justice Warren Burger and Justice Lewis Powell, who had been appointed by President Nixon. The 2 dissenters were Byron White, who had been appointed by President Kennedy, and William Rehnquist, who had been appointed by Richard Nixon. Even more dramatic, in Planned Parenthood versus Casey, the 5 justices who reaffirmed Roe all had been appointed by Republican presidents. Harry Blackmun by President Nixon, John Paul Stevens by President Ford, Sandra Day O'Connor and Anthony Kennedy by President Reagan, David Souter by the first President Bush. In Dobbs, Justice Alito wrote the opinion for the majority. It was joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett. In other words, it was Alito and Thomas joined by the 3 Trump appointees. Justice Alito said that Roe versus Wade was, quote, egregiously wrong and, quote, exceedingly poorly reasoned. The court in Dobbs said that a right should be protected under the Constitution only if it's clearly in the text or is part of its original meaning, or there's a long unbroken tradition. The Supreme Court in Dobbs said abortion doesn't fit into any of these categories. The court said that precedent deserves little weight when the decision is so clearly wrong as Roe versus Wade. The court said laws regulating abortion should be allowed so long as they're reasonable, because abortion is left entirely to the political process. Chief Justice Roberts concurred in the judgment. He would have upheld the Mississippi law, allowing states to prohibit abortions after the 15th week of pregnancy, but not going any further in reaching the question of whether to overrule Roe versus Wade. Justices Breyer, Sonoy, and Kagan wrote a vehement joint dissent. They defended Roe. They said the Supreme Court has protected aspects of privacy and autonomy under the liberty of due process clause for over a century. They said that laws that prohibit abortion infringe a woman's right to privacy. They said that laws that restrict abortion prior to viability violate the Constitution. They emphasized stare decisis. They stressed the practical effect on women's lives. Well, what's the decision in Dobbs going to mean? He said, most of all, it means that the issue of abortion is left to the political process. For now, it means it's left to the states. It's estimated that over half the states will prohibit all or virtually all abortions. And it's estimated that about half the states will continue to allow abortions. What this means in practical terms, and the dissent made this point, is that women with resources in states where abortion is illegal will travel to places where abortion is allowed. But it's economically disadvantaged women, teenagers without resources, will not have access to abortion. Before New York became the first state in this country to legalize abortion in the 1960s, about a quarter of all the abortions in England were performed on American women. It wasn't poor women who were going to England for abortions. Now, I emphasize, for now, the issue of abortion is left to the states. It's certainly possible that Congress could adopt a law protecting a national right to abortion or prohibiting abortions nationally. A bill passed the House of Representatives this past spring that would have protected a national right to abortion. It was filibustered and died in the Senate. And Senator Lindsey Graham introduced a bill a few weeks ago that he says he'll try to get adopted the next time there's a Republican Congress and Republican president that would prohibit abortions everywhere in the country after the 15th week of pregnancy, preempting laws like in California's that allow abortion. State legislatures are going to adopt a flurry of other laws with regard to abortion. There's a bill in Missouri that would make it a crime for a woman to cross state lines for an abortion. Some states like Texas already have laws that prohibit importing into the state medication that would induce an abortion. Some states are considering prohibiting forms of contraception that are thought to take effect after conception, like the morning after pill or the IUD. There's a bill pending in the Idaho legislature that would say that when there's in vitro fertilization, all embryos must be implanted, which would make the practice impossible. There's going to be a myriad of constitutional issues coming up. Do laws prohibiting abortion need to have an exception to protect the life of the woman? How is that to be determined? Do they need to have an exception to protect the health of the woman? How is that to be determined? And then there's the question about what all of the other rights protected under privacy are likely to mean in the future. Justice Clarence Thomas wrote a concurring opinion in Dobbs in which he said that he thinks now the court needs to overrule Griswold versus Connecticut, the 1965 decision that said there's a right to purchase and use contraceptives. Lawrence versus Texas, the 2003 decision that said that states can't prohibit private consensual same-sex sexual activity. And Obergefell versus Hodges, the 2015 decision that said the states can't prohibit same-sex marriage. Justice Alito, in his majority opinion, said none of these rights are in jeopardy because they don't involve, quote, potential life. But under the criteria that Justice Alito articulated, that a right should be protected only if it's in the text, part of the original meaning, or a long unbroken tradition, none of these rights would be protected. In fact, Justice Alito, along with Chief Justice Roberts and Justice Thomas, dissented in Obergefell versus Hodges, the case that created marriage equality for gays and lesbians. I think the bottom line is that Dobbs means that abortion is going to dominate our political process, dominate the judiciary at all levels for years to come. Let me talk about a second area. I'm not reading the chat as I go along. I'm going to finish my talk and then I'll go back and read the chat. I can't talk and read the chat at the same time, but I will get to the questions at the end of my presentation. A second area that I want to talk about from last term got less media attention, but can have an enormous effect on all of our lives. It involves administrative law, And the case was West Virginia versus Environmental Protection Agency. It involves the authority of the Environmental Protection Agency to regulate greenhouse gas emissions from coal-fired power plants. The Obama administration adopted the Clean Power Plan to reduce greenhouse gas emissions from power plants. The Trump administration rescinded the Clean Power Plan and adopted its own Affordable Clean Energy Plan. West Virginia, a challenge was brought to that, and the Federal Court of Appeals found that the Trump administration violated the Administrative Procedures Act in rescinding the Obama plan and creating its own. West Virginia and a couple of coal companies went to the US Supreme Court. They won in the Supreme Court in a 6-3 decision. Chief Justice Roberts wrote for the court, Justice Kagan wrote for the 3 dissenters. Chief Justice Roberts said, when there's a major question of economic or political significance, a federal agency can act only if there's clear direction from Congress. Chief Justice Roberts said that whether the EPA can regulate greenhouse gas emissions from coal-fired power plants is a major question of economic and political significance. He said, Congress has not been sufficiently specific in giving to the EPA the authority to regulate this. Therefore, the EPA can't regulate greenhouse gas emissions from coal-fired power plants. Justice Kagan wrote a strong dissent. She began her dissent by talking about how climate change is imperiling the planet and all life on it. She said the EPA has explicit authority to regulate pollution from stationary sources. Power plants are that. She spoke powerfully of the need for the EPA to be able to adopt such regulation to safeguard the environment. She raised questions about what this is going to mean for all other areas of administrative regulation, because in so many areas, Congress is given broad delegation of power to agencies. And that's what concerns me about this. What's a major question of political and economic significance? The Supreme Court doesn't say. What's sufficiently specific guidance from Congress to meet the major questions doctrine? The Supreme Court doesn't say. So this widely opens the door to challenges to a myriad of administrative regulations. Regulations by agencies of health and safety, regulations by agencies of the environment, regulations protecting business practice. The Supreme Court has opened the door to challenges, most usually by business, to the whole range of regulations from administrative agencies. The third area that I want to talk about from last term concerns separation of church and state. And here we've seen a major shift in the court on account of the change in its composition. For decades, the Supreme Court interpreted the Establishment Clause of the First Amendment. This is the provision that there can be no law respecting establishment religion, is embodying the words of Thomas Jefferson, that there should be a wall that separates church and state. On the other hand, the Supreme Court took a fairly minimal approach to the Free Exercise Clause, the provision that says that the government can't abridge free exercise of religion. The key case here was Employment Division versus Smith in 1990. There, the Supreme Court said, we don't create exceptions on account of religious beliefs from laws. There was a case that involved an Oregon law prohibiting consumption of peyote, a hallucinogenic substance. Native Americans wanted to use peyote in their religious rituals. The Supreme Court said the Oregon law wasn't motivated by desire to interfere with religion. It applies to everyone, no religious exemption. Now, though, the current court is taking a very minimal, sometimes even non-existent view of the Establishment Clause and a very aggressive view with regard to the Free Exercise Clause. Two cases from last term. The first was Carson versus Macon. It came down on June 21st. There are parts of Maine that are too rural to support public school systems. In these areas, school administrative units give money to parents to send their children to religious schools. It's to send their children to private schools. The state's giving money for the private schools, but under state law, the money has to be used at secular private schools. It cannot be used at sectarian or religious schools. It's estimated about 5,000 children in Maine benefit from this. Two families that wanted to send their children to religious schools and use the money to do this brought a challenge. The federal district court, the Federal Court of Appeals upheld the Maine law, saying the money could be used in secular schools, but not religious schools. The Supreme Court, in a 6-3 decision, reversed. Here, Chief Justice Roberts wrote for the court. Justices Breyer and Sotomayor both wrote dissents that Justice Kagan joined. Chief Justice Roberts said, whenever the government provides aid for private sector schools, it must provide that aid to religious schools.
Yeah.
He relied on a 2017 decision, Trinity Lutheran versus Comer. That case involved Missouri providing aid to schools for playgrounds. The state would provide it to any public or secular private school, but not a religious school. And the Supreme Court declared this unconstitutional. Chief Justice Roberts wrote then too, and he said it's odious for the government to support secular schools, but not religious schools. But then in a footnote, he said, this is just a case about aid for playgrounds and no more. But Carson versus Macon makes clear it's not just about aid for playgrounds. That whenever the government is providing aid for secular private schools, the Constitution requires the right aid to religious schools. To think about the implications of this, in many states, including California, there's charter schools. These are schools paid for by the government, but are privately run. California has a law that says that the charter schools must be secular. We challenge this, arguing that this is unconstitutional because it's preventing money for religious schools. Or there's many other government programs that provide aid for secular, but not for religious activities. And so, for example, many governments provide aid for the protection of historic landmarks, but exclude places used for active religious worship, like churches, synagogues, mosques. I was involved in a case out of New Jersey a couple of years ago that involved cities in New Jersey providing money for historic preservation, but not for places used for active religious worship. The New Jersey Supreme Court unanimously upheld that, but I think the result would be different today. Or there's many government programs provide aid for drug and alcohol rehabilitation. Generally, they will provide money for secular programs, but not for faith-based programs. I think these two are now constitutionally vulnerable. To explain why this is such a dramatic change in the law, for decades, the issue was, when may the government give aid to religious schools without that violating the Establishment Clause? Now the issue is, when must the government give aid to religious schools, or it violates free exercise of religion? The other religion case came down on Monday, June 27th. It was Kennedy versus Bremerton Schools. Joseph Kennedy was a high school football coach in Bremerton, Washington. He made it a practice after games of going onto the 50-yard line and kneeling and praying. He said he was a devout Christian and his religion required that he do this. A parent complained. Turned out that sometimes students from his team, sometimes students from the other team would join the coaching prayer. The parent said, my son and our family are atheists, that my son feels pressure to participate in the prayer or he'll get less playing time. The school said to the coach, stop what you're doing. The coach briefly complied. And then he began the practice of going onto the 50-yard line after games and delivering a Christian inspirational message that he called a prayer. Sometimes players from his team would join him, sometimes from the other team, sometimes people from the stands. The coach was suspended. The school gave him a poor performance evaluation. He sued and said this violated his free exercise of religion and his freedom of speech. The federal district court and the Federal Court of Appeals ruled against him. They said that the Supreme Court for over 60 years has said that prayer in public schools is not allowed, even voluntary prayer. The Supreme Court, in a 6-3 decision, reversed and ruled in favor of the coach. Justice Gorsuch wrote the opinion for the court. Justice Sotomayor wrote the dissent. Justice Gorsuch said it violated the coach's free speech and free exercise of religion to punish him for this. It's interesting that there was a major dispute over the facts between the majority and the dissent. Justice Gorsuch characterized this as the ability of the coach to pray in private on his own time. Justice Sotomayor in her dissent included pictures of the coach praying on the field, surrounded by large groups of people, suggesting it wasn't private. It was still during the event of the football game, even though the game itself was over. Justice Gorsuch said that it doesn't violate the Establishment Clause, that all that violates the Establishment Clause is if the government coerces religious participation, and there was no evidence of that. He said, deciding what violates the Establishment Clause, all that matters is what would have offended the framers in this regard in 1791. Justice Gorsuch wrote, and I quote, "The line that courts and governments draw between the permissible and the impermissible under the Establishment Clause has to accord with history and faithfully reflect the understanding of the founding fathers." Justice Sotomayor wrote a vehement dissent. He said, what about the Establishment Clause and the prohibition of prayer in schools? She said, inherently when there's prayer in schools, it's coercive. Any restriction of prayer obviously limits the free speech and free exercise rights of those who want to pray. She says, where's the stopping point? Or what's this case likely to mean in the future? I don't think this is a case about official school-sponsored prayer. But it does say that a teacher or a football coach can pray when it's so-called, Justice Alito's words in a concurring opinion, a lull in the activities. So imagine a teacher in a classroom with students before school begins, or at recess, when kids have their heads down on the desk, lunch, after school. The teacher can pray, and it's no problem for the students to join the teacher in prayer. That doesn't violate the Establishment Clause. Again, this is such a dramatic change in the law. For decades, the issue has been, when does prayer in school violate the Establishment Clause? And the answer was virtually always. Now the issue is, when does limiting prayer violate the free speech and free exercise rights of those who want to pray? The final area that I want to talk about from last term concerns the Second Amendment. And the case is New York State Rifle and Pistol Association versus Bruin. From 1791, when the Second Amendment was ratified, until June of 2008, not one federal, state, or local gun regulation was struck down by the United States Supreme Court. In the handful of cases dealing with gun rights before 2008, the Supreme Court always said the Second Amendment means what it says. It's about a right to have guns for purpose of militia service. But in June 2008, in District of Columbia versus Heller, the Supreme Court struck down a DC ordinance that prohibited ownership or possession of handguns. Justice Scalia wrote for the court. It was 5-4 and ideologically divided. And he said the Second Amendment protects a right of people to have guns in their home for the sake of security. And in 2010, in McDonald versus City of Chicago, the Supreme Court said this applies to state and local governments. But that was the last Supreme Court case about gun rights until June 23rd of this year. New York State Rifle and Pistol Association versus Bruin involves a New York law initially adopted in 1907 that limits having guns outside the home. It specifically says for concealed weapons, a person can have that only if the individual has a concealed weapons permit. And having a concealed weapons permit requires showing cause for having a concealed weapon. The New York courts have said cause requires demonstrating a safety need for a concealed weapon. California law is identical in allowing concealed weapons only if somebody could show a safety need for a concealed weapon. The Supreme Court declared this unconstitutional. The court said, the second, Justice Thomas wrote for the court and Justice Breyer wrote for the three dissenters. Justice Thomas said, the Second Amendment protects a right to have guns outside the home, including concealed weapons. He said, state laws that restrict concealed weapons to those who show a safety need for them violate the Second Amendment. Now, if that's all the Supreme Court had done, this case would be notable. because the Supreme Court, for the first time, determined that there's a right to have guns outside the home, including concealed weapons. But the court went even further. And the Supreme Court spoke to when are any kind of gun regulations allowed? And Justice Thomas, writing for the court, said, the only kind of gun regulations are those that were historically permitted, historically being either 1791 when the Second Amendment was adopted, or maybe 1868 when the 14th Amendment was ratified. Justice Barrett wrote a separate opinion saying we're not deciding whether it's 1791 or 1868. Lest you think I'm caricaturing, let me quote what Justice Thomas says. Only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that individuals' conduct falls outside the Second Amendment's command. He said the Second Amendment is the very product of interest balancing by the people, and it surely elevates above all other interests the right of law-abiding citizens to use arms for self-defense. Never, as the Supreme Court said, that the 14th Amendment elevates above all other interests the prohibition of race discrimination. Never, as the court said, that the First Amendment elevates freedom of speech above all other interests. For all other fundamental rights, the government can act if it meets what's called strict scrutiny, if what it's doing is necessary to achieve a compelling purpose. The government can discriminate based on race if it meets strict scrutiny, if its action is necessary to achieve a compelling purpose. The government can interfere with freedom of speech, even of viewpoint discrimination, if it's necessary to achieve a compelling purpose. But not when it comes to the Second Amendment. For the Second Amendment, the only regulations to be allowed are those that were historically permitted. You might have seen a news story just last week that a federal court struck down a federal law that made it a crime to sell guns without serial numbers on the ground that there weren't serial numbers on guns in 1791. I've done a lot of speaking at judicial conferences in the last few weeks, and I think that this decision will put in jeopardy a whole host of gun regulations that require in every instance that the inquiry be, was this a kind of gun law that was allowed back in 1791 or maybe 1868? Well, when you look at abortion, administrative law, separation of church and state, and the Second Amendment, these are some of the most divisive issues in society. And the Supreme Court has solidly come down on one side of that political divide. Let me talk for a bit about this term of the court, and then I'll take the questions that I see coming in the chat. This term began just a couple of weeks ago on Monday, October 3rd, the first Monday in October. The most notable change on the court is that after 28 years, Justice Stephen Breyer has retired and is replaced by Justice Ketanji Brown Jackson. Justice Jackson is 51 years old, and even if she doesn't change the court's ideological balance today, she well might in the future. She brings unique perspectives. She's the first Black woman to serve on the court. She's the first former public defender to serve on the court. Well, let me start with some of the cases that are on the docket. Given the organization sponsoring this, let me start with some of the election cases. If you ask me what's the case that I am most looking at, and for that matter, most worried about this term, I would say it's Moore versus Harper. This will be argued to the Supreme Court later this year. You might have heard of it referred to as the independent state legislature theory. Here's what it's about. In 2019, in Rucho versus Common Cause, the Supreme Court said that federal courts can't hear challenges to partisan gerrymandering. Partisan gerrymandering was the political party that controls the legislature, draws election districts to maximize seats for that party. North Carolina went through redistricting after the 2020 census, like all states did. The Republican-controlled state legislature gave Republicans control of 10 or maybe 11 out of 14 congressional districts. North Carolina is basically a purple state, split almost 50-50 between Democrats and Republicans. The North Carolina Supreme Court found that the partisan gerrymandering violated the North Carolina state constitution. The Supreme Court said federal courts can't hear challenge to partisan gerrymandering, but even acknowledged that state courts could. Well, the North Carolina legislature has gone to the Supreme Court, said, US Supreme Court, said the state Supreme Court lacked the authority to do this. They said under the Constitution, the legislature gets the last word, and what it does isn't reviewable by the courts. They point to language in Article 1, Section 4 of the Constitution that says that the legislature of each state shall control the time, place, and manner of elections to Congress. They say that gives the legislature sole power, no matter what. The courts can't get involved and can't review. Now, there's another provision too that gives state legislatures power. It's in Article 2, Section 1. It says that the legislature of each state shall allocate the electors from that state in the Electoral College. Imagine the Supreme Court buys the independent state legislature theory. Imagine the 2024 presidential election is as close as the 2020 presidential election. And imagine that there's a few states, hypothetically make them Wisconsin, Georgia, Arizona, with Republican legislatures. But imagine the Democratic candidate again wins the popular vote. Under those state laws, the Democrats should get the electors of the state. But what if the legislature says, no, independent state legislature, we get to give the electors we want and courts can't review? To me, this is a very troubling theory that really could put our democracy at risk. Legislatures, in exercising their powers, always must do so in accord with the Constitution. Congress has to do so in accord with the US Constitution. State legislatures have to do so in accord with state constitutions. And it's always the role of the judiciary to make sure that the legislatures are adhering to the Constitution. The independent state legislature theory would leave this entirely to the legislature of the state with no judicial review. So stay tuned for the argument and the decision. Another case about elections was argued on Tuesday, October 4th. It's Merrill versus Milligan. It involves the Voting Rights Act. I regard the Voting Rights Act, 1965, as one of the most important laws adopted in my lifetime. The Voting Rights Act did many things. It required that jurisdictions with a history of race discrimination voting get pre-approval, pre-clearance before changing their election systems. The Supreme Court declared this unconstitutional in 2013 in Shelby County versus Folder. It said that jurisdictions with state and local governments cannot have election practice systems that discriminate against voters of color. The Supreme Court in July 2021 in Brnovich versus Democratic National Committee made it much harder to use Section 2. Well, Merrill versus Milligan involves Section 2 of the Voting Rights Act as it applies to the drawing of election districts. Alabama is a state where 27% of the population is Black. When the Alabama legislature drew election districts after the 2020 census, they drew them so that there likely be only one Black representatives in Congress from Alabama. There's a majority Black population in one of 7 districts. They packed Black voters in one district and spread them out among the other districts. A 3-judge federal district court found that this violated the Voting Rights Act. 2 of the judges on that panel were appointed by President Donald Trump, one by President Bill Clinton. The United States Supreme Court granted review, and many believe that the Supreme Court is going to substantially weaken the Voting Rights Act in this case. Another matter before the Supreme Court this term involves affirmative action. On October 31st, the Supreme Court is going to hear 2 cases involving affirmative action. Students for fair admission versus University of North Carolina, and students for fair admission versus Harvard College. In decisions spanning over 4 decades, the Supreme Court has said that college universities have a compelling interest in a diverse student body, that college universities may use race as one factor among many in admission decisions to benefit minorities and enhance diversity. The court said this in 1978 in Regents University of California versus Bakke. The court said this in 2003 in Grutter versus Bollinger. The court reaffirmed this in 2016 in Fisher versus Texas Austin. But 2 of the justices who are in the majority in Fisher are no longer on the court, Justices Kennedy and Ginsburg. All 3 dissenters, Roberts, Thomas, and Alito, are there. And they're joined by 3 Trump appointees, Gorsuch, Kavanaugh, and Barrett. I think everyone, liberal and conservative, believes that the Supreme Court is likely to overrule the earlier precedents and eliminate affirmative action. The reason there are two cases is equal protection in the Constitution applied to the government. That's the University of North Carolina. Private schools don't have to comply with the Constitution. But with regard to private schools, Title VI of the 1964 Civil Rights Act says that they can't discriminate on the basis of race. The recipients of federal funds can't discriminate on the basis of race. And so the argument is that Harvard is violating Title VI. My prediction is that the Supreme Court is going to say that affirmative action, whether by public or private universities, violates the Constitution and Civil Rights Acts, respectively. And I do think it's going to have a devastating effect on diversity in colleges and universities. A final case that I'll mention by way of preview, and then I'll shift to questions, is the case called 303 Creative versus Alenis. Lori Smith lives in Colorado and has a business designing websites. She wants to design websites for weddings, but refused to design websites for same-sex weddings. Colorado has a law that prohibits discrimination by business establishments on grounds of race, sex, religion, sexual orientation. She brought a challenge to this law, saying it violates her religious freedom. The Federal Court of Appeals, the United States Court of Appeals for the 10th Circuit, ruled against her. The 10th Circuit said the government has a compelling interest in prohibiting discrimination based on sexual orientation. The Supreme Court granted review on the question of, does her freedom of speech give her the right to decide what websites to design? This might remind you of a case from 2018, Masterpiece Cake Shop versus Colorado Civil Rights Commission. And this involved a baker who refused to design and bake cakes for same-sex weddings. The Supreme Court ducked the issue, but is now squarely before the court. There's always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to discriminate. But for decades, the court, our society have made the choice that stopping discrimination is more important than protecting the freedom to discriminate. Now I think the Supreme Court is going to say that there is a freedom to discriminate on the basis of religion, on the basis of speech. Let me just, by way of conclusion, before getting into the questions, say, I've described to you last term, I've talked about what's on the docket this term. We've got to remember the age of the justice we look to the future. Justice Clarence Thomas is the oldest conservative, the oldest justice, he's 74. Samuel Alito is 72. John Roberts is 67. Justices Gorsuch, Kavanaugh, and Barrett are all in their 50s. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. So it's easy to imagine 5 or 6 of these justices being together for the next decade or two. The Supreme Court has the lowest opinion ratings, the lowest approval ratings at any time in its history. A Marquette University poll in July gave it 38% approval, 61% disapproval. At a time when our society is so politically polarized, what will it mean for the Supreme Court to have solidly come down on one side of that political divide? That, I think, is the key question for the future. Let me now turn to questions. There are many in the chat, and I may have figured out what was wrong with the speaker. Maybe not. I thought I had, but that doesn't seem to work. Let me just take the questions and read them from the chat and answer them. You can still hear me okay? Thumbs up?
Yep.
Okay, then I can read the questions, and there's many in the chat. I won't get to all of them, but I'll read them. Let's assume that Congress will sooner or later pass a law to outline abortions, no exceptions neighborwide. Given the opinion of the court's liberals in relation to the medical marijuana case, that free homegrown, purely in-state medicine falls under Congress Commerce Clause Authority, even when there's no market or interstate commerce. How can California and other states keep it legal to obtain, provide, or be involved with an abortion provided free for a state resident? They can't. The question would be, does the law fit within the Congress's commerce power? You rightly point to a case, Gonzalez versus Raish from 2005, where the court said it's commerce if it's something that's bought and sold. Abortion services are paid for. And if you look at it cumulatively across the entire country, is there an effect on interstate commerce? Well, the answer seems clearly yes with regard to abortions looked at cumulatively. So I think Congress is likely to be found to have the authority to do this, and it can preempt state laws that provide for abortion.
But what about, if I'm
Does this-
on,
State statutes, state constitutional provisions, and the like. I think the hope would be to try to make sure that Congress doesn't do this. That if there's a Republican Congress, Democrats in the Senate would filibuster it, or try to make sure that there's not a Congress that would pass such a law. Next question. It seems to me that women are being pushed back to the late 19th century. Hasn't the Supreme Court gone beyond its scope? The Supreme Court in Roe versus Wade found that there was a right of women to choose whether to terminate their pregnancy. I agree with the court decision because I think privacy is protected under the liberty of the due process clause, and that laws prohibiting abortion infringe privacy. But just as the court can find a right, so can the court overrule its decision and take the right away. What about separation of church and state and abortion? I think a common sense view of the government's involvement in this medical issue is effectively a Christian version of Sharia law. But the fact that a law might have religious origins doesn't make the law unconstitutional, so long as there's a secular purpose for the law. Laws prohibiting murder might be tied back to the 10 Commandments, but since there's a secular purpose, that doesn't make them invalid. The Supreme Court accepts and says explicitly in Dobbs that it regards the states as having a valid secular purpose in the protection of potential life, and the court sees that as not being a religious base for it. So the fact that there's a religious foundation initially doesn't mean that it violates the Constitution, so long as there's an articulable secular purpose, and the court believes that there's one here. What role did equal protection play, or should have played, in the Maine rural kids school vouchers case? There was an equal protection issue, but the Supreme Court didn't decide it. I think the reason for that is if the state can deny funds to religious schools because of the Establishment Clause of the First Amendment, then it doesn't violate equal protection to do so. And if a state can't deny funds to religious schools because that violates the religion clauses, then that violates equal protection too. So where in the Constitution does it say the Second Amendment is for self-defense versus for militia? It doesn't. The Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's all it says. And that's why from 1791 to 2008, the Supreme Court said that the Second Amendment is just about a right to have guns for the sake of militia service. But now, in District of Columbia versus Heller in 2008, the Supreme Court said that the Second Amendment protects a right to have guns for the purpose of self-defense in one's home, or even now out in public. That's the Supreme Court's interpretation of the purpose of the Second Amendment. It's not found in the text of the Second Amendment. Any questions? Oh, lots of questions. In reading many books about the writing of the constitutional papers, I think the Second Amendment grants the right for states to have well-regulated militias with nothing but rights. I agree that that is the position that the Supreme Court took prior to 2008, that the Second Amendment was really about making sure that Congress didn't regulate state militias in a way that keeps states from protecting themselves, that it wasn't about an individual right to have guns. That's the argument that Justice Stevens makes in his dissent in District of Columbia Heller, but the court rejects it in the majority opinion by Justice Scalia. Since EPA was created to deal with regulated pollutions, what kind of additional authority needed allowed to regulate CO2? Well, I think it can regulate CO2, but when it comes to regulating CO2 from power plants, the Supreme Court said Congress needs to pass specific authority that the EPA has the authority to regulate CO2 from coal-fired power plants. The court thought that the general authorization wasn't sufficient. It needed to be more specific. It doesn't mention self-defense only to well-regulated militia, yes. If a state enacts a law that permits abortion, will it overcome the federal prohibition of abortion in light of overruling Roe v. Wade? What the court did in overruling Roe is say that abortion is left to the political process. States that want to can prohibit abortion. States that want to allow abortion can do that. The court didn't say that the Constitution prohibits abortion. Quite the contrary, that said the whole issue of abortion is left to be political process. So for now, it's the states, it's the Congress. Congress chooses to act. In California, if you've got camping and intent, you shoot somebody in self-defense or other, can the castle doctrine protect you or you're in trouble? I don't know the answer to that question. I don't know the law with regard to being an intent in California. Now Congress would have to specifically say so. Good luck getting past the filibuster. If Congress wanted to pass a law protecting a national right to abortion, they have to pass both the House and the Senate. They would either need to get past the Republican filibuster, or the Democrats have to be willing to change the rules with regard to the filibuster. So far, they've been unwilling to do. What can we as ordinary citizens do to affect democracy for this court, which appears based on a theocracy based on originalism? I am enormously critical of originalism. If I this will sound like a shameless plug. The new book that just came out in September, titled "Worse Than Nothing: The Dangerous Fallacy of Originalism." I also am very critical of work that I think is advancing religion. In terms of your question, what can people do? Get involved. Get involved in organizations like this. If what you care about is abortion rights, get involved with organizations like Planned Parenthood that are working hard for abortion rights. If you care about gun rights, get involved in the organizations like the Brady Center. If you care about issues with regard to civil liberties more generally, get involved in the ACLU or the NAACP. That's fine. We as individuals gain power when we come together in groups, and these organizations are crucial in doing all we can to protect rights. And of course, exactly what Legal and Vote is about, encouraging people to get out and vote. Okay, there's more questions. Give me a second. Oh, I hope it's been accessible. I've tried to not be technical. I talk too fast, but I hope that I've been able to clearly communicate what it's doing. With Dobbs affected Loving versus Virginia was the 1967 case that involved the Virginia law that prohibited interracial marriage. In a Loving versus Virginia, the Supreme Court said laws that prohibit interracial marriage violate equal protection as race discrimination. They violate due process, as violate the right to marry. It's interesting. When Justice Thomas said he wanted to overrule Obergefell, he didn't mention overruling Loving. I don't think that states are going to again adopt laws prohibiting interracial marriage. So I don't think the court's going to have occasion to reconsider Loving. And I guess what the court would say is, even if it overrules the right to marry and say that doesn't exist, still Loving involves race discrimination, and that would violate equal protection. Reminder that our speaker isn't able to hear us, so please put your questions in chat. I gotta figure out why I wasn't able to hear you. Can a private school segregate federal funds, keeping them from use for minority affirmative action offense and still use affirmative action? What the Supreme Court's likely to say is that private schools that receive federal funds cannot discriminate based on race. That would be period, that they can't discriminate on the basis of race. So in their admissions decisions, they can't use race as a factor. For scholarships, what's been done by public universities like California is there can be private foundations that have scholarships, say, for students of color, and the private foundation can then decide who to give money to. But when it comes to admissions decisions, they're not going to be able to discriminate on the basis of race. Actually, originalism cuts both ways. We can argue for gun regulation or the original intent of the founding fathers to gain satisfaction was laissez-faire. We're going to have states elected electors like their college. That does not bode well for resisting the intent period. Well, in fact, when the Constitution was written, in many states, it was the state legislatures that chose the electors to electoral college. It wasn't popularly elected legislatures. It wasn't the popular vote of the people. It was the legislature that chose the electors to electoral college. It wasn't the people voting for president. You're right, that doesn't bode well. On the other hand, all of the states now have laws that say that the electors of the state will go to who wins the popular vote. My argument would be, having adopted such a law, the legislature can't back away from it and give the electors to somebody other than one the popular vote. Where can I find an answer as to whether a castle document protecting on tent camping or shooting an attacker? Is my tent in that castle? I don't know if there's law in it. One could research the state law and how it treats tents in this regard. I don't know the law with regard to tents. Do you like my congressman support expanding and recapping the court for term limits? It's a good place to end since we're almost out of time. Yes, I support term limits in favor of 18-year non-renewable terms. Some of it is that thankfully life expectancy is a lot longer today than it was in 1787. Then the average life expectancy was 38 years old. Clarence Thomas was 43 when he was appointed to the court in 1991. He stays till he's 90. The age Justice Stevens retired. He'll be a justice until 47 years. Amy Coney Barrett was 48 when she was confirmed 2 years ago. She stays on the court until she's 87. The age Justice Ginsburg died. She'll be adjusted in 2059. That's too much power in one person's hands for too long a period of time. Also, too much depends on the accident of history as to when vacancies occur. Richard Nixon got to pick 4 justices in 2 years. Jimmy Carter got no justices in 4 years. Donald Trump picked 3 justices to the court in 4 years as president. The prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, Barack Obama, served a combined 20 years in the White House. In those 20 years, they were only picked 4 justices. 18-year non-renewable terms with staggered terms. Every president picked a justice every 2 years. I do favor expanding the size of the Supreme Court, but it's not going to happen. The size of the Supreme Court is set by federal statute. It can change by federal statute. But it is sure to be that the Republicans would filibuster any effort to expand the size of the Supreme Court. So it's not something likely to happen. So I don't see those reforms. I see that I'm out of time. I thank you for having me. I apologize for the sound problems, but by next time I do this for you, I'll get them fixed. Thank you.